state and public officers from doing business with government. Ibrahim Karanja reports about proposals that mutilated the bill that also seeks to shield the public servants from requirement to declare their wealth in a Senate session of the 15th of May 2024 that now even has the moral agency EACC opposed to it.
Activities on the floor of the Senate of the Republic of Kenya on the 15th of May 2024 may have escaped the attention of the public owing to the furore created by the Finance Bill 2024. By then, contents in the Finance Bill were just proposals, and the country was deep in the conversation of an increase in taxation. But something more sinister was happening at the Senate, where 25 members were unanimously and mercilessly watering down a crucial bill initially meant to make it impossible for governors, cabinet secretaries, principal secretaries and parastatal heads, among others, from trading directly with the state. The amendments endorsed by the senators and which now requires the nod of the National Assembly has given public officers a free hand to take part in procurement and assets disposal relating to the offices they serve in. More than a month later, NTV wishes to bring the attention of the general public to what befell the Conflict of Interest Bill 2023 National Assembly Bill as it entered the Senate as a stringent and strict proposal, leaving the House limping, toothless and largely ineffective due to mutilation. Narok Senator Ledama Olekina was the lead mutilator of the bill, proposing that stringent measures against conflict of interest by public officers be stricken out, instead leaving a flowery document that was sent back to the National Assembly for consensus. Interestingly, all of the 25 members present in the House during the session voted in support of the amendments. By keenly going through the original draft and following Hansard records as well as video recordings for the 15th of May 2024 proceedings, NTV now highlights some of the clauses stricken off and their meanings and impact thereof, even as the proposed amendments by the Senate awaits concurrence by the National Assembly before the bill is forwarded for assent by President William Ruto. Developments that have already attracted a cry for help by the Ethics and Anti-Corruption Commission, EACC.
The Commission has raised concerns and written to the National Assembly of Kenya, asking the National Assembly to consider rejecting the proposals of the Senate of the Republic that have been made or proposed for the Conflict of Interest Bill 2023. The Conflict of Interest Bill went to the Senate for consideration, but the Senate proposed changes that will have far-reaching implications in the fight against corruption if the bill is passed in the manner proposed. In the proceedings, aside from amending some clauses, Senator Olekina moved that some clauses be completely deleted. Here's a list of the deleted clauses out of the proposals. Let's now take a look at just some of the deleted clauses and what they meant. By deleting Clause 20 of the bill, the Senate allowed public officers to acquire interests in partnerships, private companies and other legal entities that is a party to a contract with the public entity in which they serve in, and further allows them to have benefits through such partnership. By removing Clause 23, this is what the Senate did. It allowed public officers while serving in reporting entities to engage in other gainful employment even if it may result in the impairment of judgment of the public officer in the execution of official duties, or even if it may result in conflict of interest. Section 31 of the bill had made it a requirement that every public officer submits a declaration of the income, assets and liabilities of himself, his spouse or spouses, and his dependent children. This too has been deleted by the Senate, just as has been deleted Section 34 that made any such declarations accessible to the general public. By deleting Section 36, it is no longer an offense when a public officer fails to submit such information as is required.
Clause 37 of the bill had made it an offence for a public officer to submit information which they know to be false or misleading, and that too has been unanimously deleted by the Senate. Yet another deletion is that of Clause 50, Subclause 1, which provided for the suspension of a public officer pending the investigation and determination of allegations made against that officer, where that suspension is considered necessary. Currently, there are several cases in court where top government officials and other public officers are facing charges including conflict of interest. They are charging strengthened by Section 42 of the Anti-Corruption and Economic Crimes Act, ASECA. The bill now scraps off that particular act, making it impossible to charge public officers involved in conflict of interest.
More worrying, and this is a concern that the EACC has made known to the National Assembly, is the fact that the Senate proposed in the bill to amend existing laws by way of repealing existing provisions, and one of them is the provision that makes a conflict of interest a criminal offence under the Anti-Corruption and Economic Crimes Act. That is a dangerous move if the bill becomes law, because conflict of interest is the bedrock of the major scandals and the major corruption cases that EACC investigates, including the cases out of which 10 governors are in court today. That is why you see top officials charged alongside family members and associates.
The changes flies in the face of cabinet resolutions of last February, when it endorsed the bill and has dealt a blow to the Kenya Kwanza commitment to fight graft. It is now up to the National Assembly to reject the proposals, as is required by the EACC, and come up with a mediated version that retains the originality of the bill. Ibrahim Karanja, NTV.